Go ahead and get started. Alex and Kent, are you ready?
Yes, we are. We're here.
All right, terrific. And we've got the mood music off now, so that was a fun addition to the interactive dialogue concept. We thought that the folks that are listening in might want to know for sure that they're actually listening into the right program. So if you happen to be sitting next to someone who's saying, hey, my computer isn't working, I can't hear anything, nudge them and remind them that they need to also dial in to the 800 number, which I've circled on the screen as well. So welcome everybody to this edition of the Interactive Dialogue. First, a quick shout out of gratitude and appreciation to Rima Murphy and Jane Wilgus from our Minneapolis office, who we learned braved minus 33-degree temperatures to somehow get their cars started and drive into the office to launch this program. So Rima and Jane, thank you again for your extraordinary service to Dorsey and to our clients. We're here to talk about really a fascinating topic of in the food and beverage and agribusiness industry. For those of you who have not been part of the Interactive Dialogue series before, our objective in these programs is to take a topic that's of interest to our industry and then pick some experts. We've got two fantastic experts today, and delve into that topic in a way that's a little bit more interactive, meaning instead of 75 substantive slides and we yell as fast as we can through the internet, what we're going to do is have a smaller number of more substantive slides and then talk through what those slides are and the practical implications for our clients. And it's always fascinating to watch people log in. We've got folks logging in today from California, Minnesota, Utah, New York, Illinois, all around the United States. So welcome to this program. We'll be addressing the slides as we kind of go along, but in addition to me asking questions, we really would like this to be interactive. So as you'll see at the very bottom of your screen, your login screen, you'll see a blue icon with little comment bubbles, and that icon is there for you to ask questions as well. So if you post a question there, it'll come to me as the presenter, and then I'll weave that question in to the questions that I'm asking so we can make sure and address them to the extent that they're connected in here with the topic. And then if you'd like to keep that confidential, we're happy to do that as well. Just say something about like it to be confidential, and we'll make sure to do that. So Dorsey and Whitney, as those of you who have worked with the firm before know, is a 600-lawyer firm. We've got 20 offices around the world and practice in a variety of different industries, but one of our 6 focus industries is food, beverages, and agribusiness. And today we're joined by two of the 200 people that make up that practice and industry group, Alex Krasovec and Kent Schmidt. So Alex, could you give a brief summary of your background?
Sure. Mike, thanks for the introduction. And again, my name is Alexandra Krasovec. I'm an attorney in Dorsey's Southern California office. A large portion of my practice focuses on defending businesses against a wide range of consumer protection claims, particularly those brought under federal and state statutes. A few of those would be the Telephone Consumer Protection Act, Fair Credit Reporting Act, and what we're here to talk today, California's Proposition 65.
Terrific. And Kent?
Yes, thanks for having me on the webinar, Mike, and thanks to all of our participants. My name is Kent Schmidt. I'm a partner in the trial group, the product liability section at Dorsey and Whitney, and I've been with Dorsey for 20 years, just over 20 years. And I figured out this morning, 18 of which I've been doing Prop 65 work. My first Prop 65 case was in 2000, so I've done a lot of Prop 65 litigation. I focus, obviously on the litigation side of things and connect with colleagues in our regulatory group when it comes down to the nitty-gritty issues of the science and exposure levels and working with the labs. But the litigation on the Prop 65 work I've been doing quite extensively, both the private litigation brought by individuals as well as attorney general or other public enforcer lawsuits and settlements.
You know, it's always fascinating when you go and take a walk in the time machine and realize that somebody who was born the day that you had your first matter can vote now. So congratulations, and having worked with you for that 20-year period, it's a privilege to work with you, Kent. And, you know, I was doing the same actually in regards to this topic, because I recall very directly when the Prop 65 came to pass. I was working in Santa Cruz, California at an amusement park there, and Prop 65 occurred, and I remember it being a lot of discussion about triangular warning notices and flyers that were unintelligible unless you had a PhD level background in science. Kent, can you describe how the Prop 65 of 1987 yesteryear has evolved?
Sure, I'd be happy to. First of all, it's evolved primarily on the regulatory side through the implementing agency, not through the California legislature. One of the things that was unusual about the law when it was passed is it has within it a requirement that it requires a two-thirds vote of the California legislature in order to make amendments to the law. And so very seldom do we ever have changes brought to the actual statutes. We have lots of changes that have been occurring, including significant changes last year to the implementing regulations, as well as constant changes to the guidance. But it is a very unusual statute. I think perhaps the most unusual aspect of Prop 65 is that its objective is achieved in an indirect way. That is to say, the real objective of Prop 65 is that product manufacturers and other defendants will reformulate their products or make changes to their facilities in order to not have to include a warning. But it implements that objective or advances that objective by requiring a warning. I would say that it is a law that is intended to be onerous. It is intended by those that dreamed up this concept that you would not have to put a warning on your product, speaking particularly of the product exposure context, but instead that you would reformulate your product such that it would not require a warning. It is also unusual in that it has a very significant penalty that is attached, $2,500 per exposure. And in the product text, every single individual in California that is exposed to the product has standing to bring a claim, and that is a penalty per exposure. So you can imagine that for a lot of these cases, we're talking about millions and millions of dollars of penalties.
Can I ask you a couple of questions about this? Because, you know, it's interesting. You know, first is that you identified the supermajority component. Is that something that's pretty common under California law, or is it fairly rare?
No, that's pretty rare. The Prop 65 is a rarity in that regard.
And did they explain why they put the supermajority in at the time, or do we know really?
Well, because it was by a proposition. As we have in California, we have extensive number of propositions on the ballot, probably 7 to 8 propositions each year. And I think the fear was that industry would start lobbying the legislature to start making changes and water down the effect of the statute or of the proposition after it became law, and so that prevents that from happening.
So it's an interesting dynamic for those outside of California, and I would say to some degree not on the West Coast, that in many of those jurisdictions, the people can make a proposition or have an initiative that would become law if it's voted on. It can be placed on the ballot with certain number of votes. And of course, folks that want a particular political agenda often will draft the petition in a way, or in California's case called the proposition, in a way that's designed not only to effect their regulatory objective, but also to get protections around that being reworked. And so we often will find this, not just with Prop 65, but other propositions or initiatives as well, that there are a lot of unintended consequences because the drafters aren't really taking all the various angles into account, or in some cases, as you just described, Kent, intended consequences, in this case, to protect the proposition from, quote-unquote, interference by the legislature, right?
That's correct. And one of the things that has been created by the statute is a cottage industry of lawyers very focused on the leverage that they obtain from the threat of a $2,500 per exposure penalty, as well as attorney fees that they can obtain. And so you have private enforcement of Prop 65 through these attorneys who do nothing other than, send out investigators into grocery stores, pulling products off shelves, taking them to the lab, having them tested, and then coming up with a theory that there's an exposure, sending a 60-day notice letter, which is the first step to bringing a Prop 65 warning case, a Prop 65 case, and asking for information relating to any of the testing that's been done to substantiate a claim by the manufacturer defendant that a warning is not required. It is also a very unusual statute with respect to the burden. Once the presence of the chemical or carcinogen has been established, the manufacturer or other defendant must then show that the exposure level is such that a warning is nonetheless not required. This is a very difficult and highly technical analysis.
So let me ask you some questions, Ann, about some of this before we move on to the next slide. First is this penalty. If I'm selling a product for $20 or $10, is it still subject to the $2,500 per exposure penalty if there's a problem?
Yes. The $2,500 does not, it has no bearing or no correlation to the product. And
so however many units are out there for sale within the state of California, that's the extent of my exposure if I learn that there's an issue, right?
Correct. So the first conversation that I always have with a plaintiff's lawyer who sent a 60-day notice letter, the first question they have for me if we want to try to figure out a settlement is, what has been your sales within the applicable period in the state of California? Is there any way to track the sales? And obviously the higher the sales, the higher the settlement value from the plaintiff's perspective.
And then it sounds like by the time you get that notice, the burden is almost shifted already in practical terms, because they have some scientific proof, quote unquote scientific perhaps, but they at least have some basis for asserting that there is a chemical in that particular product. Is that right?
Sure, but there's a question sometimes of the adequacy and sufficiency of their testing. So we usually then go into an informal information sharing period of time where we will say, and this is all pre-lawsuit, this is in the 60-day notice period, where we will say, you show us your testing, we'll show you our testing, and we sort of have a condensed battle of the experts where we're trying to prove that there's something wrong with their protocols or their testing, and they're saying this is what our experts have come up with, and that can sometimes be the basis of a pre-lawsuit settlement.
I remember you telling me a short while ago, Ken, about a conference you had attended of lawyers who specialize in being plaintiffs in these kinds of cases. How many people were at that conference?
It's hard to tell in terms of the divide, but at these conferences that I like to attend on Prop 65, there'll be 400 or 500 people at these conferences, and you go up to people and start talking to them, and the first The question is, what side are you on? Are you us or them? And I would venture to say that a pretty significant number, maybe a quarter of those, are on the plaintiff side. There are firms that are renowned. Some of the leading firms, nothing but Prop 65 cases. I've probably litigated, a dozen or so cases against them. So we see each other in the space constantly. And then there are other smaller firms like, plaintiffs firms, the class action firms that do other consumer product cases that will only do a few Prop 65 cases every year. So it's quite a variety of law firms that are involved on the plaintiff side of Prop 65.
Now, I noticed that the final bullet point here relates to settlement approvals and transparency, and you're referencing the OEHHA. Can you describe what that is and how it works?
So yes, we call it OHIHA. It is the
like OHIHA?
So yeah, OHIHA is the Office of Environmental Health Hazard Assessment, and it is the implementing California agency that is very involved, along with the Attorney General's office, in Prop 65 administration. So
when you had described before that the regulations and guidance was the main force of change here in Prop 65, is it this organization that issues that regulation and guidance?
That is correct. And then separate from OEHA is the California Attorney General's office, and that's where they're very involved in the settlements. So the California Attorney General's office has to be notified of any Prop 65 settlement. They have an opportunity to weigh in on the settlements, and believe it or not, from time to time they do, and oppose these settlements, which have to go before the court and be court-approved settlements in order for them to be valid Prop 65 settlements. The court is going to be very interested in how much money the plaintiff is receiving, the apportionment of that money. Some of it goes to the state, some of it goes to the organization, the plaintiff, and some of it, of course, is attorney fees. So that is a significant issue.
And then that means that if you receive one of these 60-day notices, you would, and that would occur before a lawsuit's filed perhaps, but if you do agree to settle, you still have to have a lawsuit filed technically in order to get the approval? Is that the case?
Yes, it's like a prepackaged. So the way we settle these cases is we come to an agreement during the 60-day period. We're going to pay an amount, but then in order to make that settlement done the appropriate way, the lawsuit has been nonetheless filed immediately with a notice of settlement.
Now, I understand that the OHIHA has issued some new regulations recently, effective only a few months ago. Can you describe what those new regulations did?
Sure. We'll be getting into this in greater detail, but one of the primary focuses of the new regulations has to do with the content and the methods of transmission of warnings. What is a sufficient warning in terms of what the consumer is told or how the consumer is informed of it? Another aspect that we'll be talking about here shortly also is how the liability is apportioned, and that's been a significant issue all the way along for many years. We've now received some clarity with respect to that, because it's always been the case, and still is technically, that any of the defendants in the chain of distribution are potentially liable as a defendant in a Prop 65 case. So that goes from the ultimate manufacturer to the distributor to the retailer. And so there's been some clarity with respect to how these parties in the chain of distribution can apportion liability. And the changes are very much focused on this injustice that's created when the small retailer which really doesn't know a lot about Prop 65 or all the products that are being provided to them and that they're selling. They don't know about the ingredients that go into the product or the exposure. And so how to protect them, because they're not in a position to make changes and do reformulations, how to give them some measure of protection so that they can discharge their duties by obtaining essentially a representation from the party that they're buying the product from. So that's been a very significant change, as well as some safe harbors that relate to particular food and beverage and how that is communicated. So that, of course, is the focus of our discussion today.
I was fascinated by the idea of an overwarning phenomenon. Can you describe the concern there?
Sure. It's the boy who cried wolf. It's, that manufacturers will ignore the objectives of Prop 65 and just say, hey, I'm just going to put a Prop 65 generic warning that doesn't identify the chemical. I'm not going to do any testing. I'm going to still be, sourcing my raw materials from questionable manufacturers, and I'm just going to slap a Prop 65 warning on everything, and then I have immunity. And Californians are very used to just ignoring those Prop 65 warnings, disregarding them, not taking them seriously because of this overwarning. So by now requiring, in many contexts, the identification of the chemical or carcinogen that is the subject of the exposure, you're requiring some type of testing to be done to identify what that chemical or carcinogen is, and maybe the individual consumer is going to take this more seriously. Now, in the food context, there's not as much of a concern about overwarning, I don't think, because people take warnings on Prop 65 warnings on food products that they're going to actually ingest with greater seriousness, perhaps, than just a Prop 65 warning that's attached to a power cord or some other household appliance or put on a box that comes in the mail relating to an article of clothing or something of that nature. So getting back to the earlier point I made, the objective really here is for, in the food and beverage space, to do everything possible to avoid a situation where you have to do a warning, and instead to reformulate and ensure that a warning is not required.
So, Alex, it references here on this slide that there are specific safe harbors in regards to the food and beverage industry. What exactly how does the regulation deal with the food and beverage industry generally?
So there's a little bit of a structure to the way that the new regulations work. First, there's an initial kind of general applicable concept of what type of warning is required here. For those general warnings, there's, as Kent mentioned, content and methods of transmission. Those are safe harbor warnings that would generally apply if nothing more specific set forth in the regulations relating to whatever it is that you're selling or potentially exposing a consumer or another user to. And so in the context of food, beverage, and alcohol, which is a separate category, the regulations actually provide for specific warnings that are required for those categories of products. And so in those, they have the same kind of structure with methods of transmission and content. So for methods of transmission, that's going to be how you're conveying the warning, and your content is exactly what's required.
So when you say method of transmission, is it transmission of the warning or transmission of the chemical?
Transmission warning. So with your food products, basically most of these exposures are going to be happening with ingestion. So it's really the methods of transmission pertains to how you're providing the warnings. With food products in particular, there's two primary methods that the consumer would be getting the warning. One of them is going to be, well, really technically three. One of them is on the product itself. For example, you buy something at the grocery store and it's on the box. Another is by a warning that happens in the form of a sign either on a shelf if you're at a store or if you're at a restaurant when you go to purchase a product or on a menu. And then the third way is if you would have an online or catalog situation. This harkens back to the general warnings, but it applies across the board that you would be required to have that online warning at the point of sale in addition to any warning that would be having to be provided on the product.
One of the participants asked a fascinating question in the context of cannabis now being legal in California. And if somebody had a food product like a gummy or the like that had a cannabis-oriented product like CBD oil or something similar to that, how would they determine whether cannabis is something that would require them to issue a content warning on that particular kind of product?
So there's a few things that go into this assessment. I mean, the first easy low-hanging fruit is running it through the list, which is available on OEA's website. It's just the Prop 65 website, which actually has to be provided on the warnings. So you can see it here on the slide that we're looking at. The next thing is any sort of anything that the cannabis would be exposed to or any other ingredient in the product would be exposed to in the course of the manufacturing process that might leach into the product. This could even include packaging. And then you also have tangential issues, and we'll get into later, but that deal with other types of exposure. So not just the consumer exposure, but any sort of exposure that would happen in the, in the environmental context or in the occupational context.
And then is
so it's
there
actually
any...
quite a complicated question.
I figured, and that's why it's helpful, and possibly one that doesn't have a clear-cut answer right now, but it's helpful for participants to understand, as you described, how do you drill down to the answer. And then kind of a similar question is, this relates to food, quote unquote. What constitutes food? How do you figure that out? What kind of foods does it apply to?
So my take on this is anything you're ingesting that is, like commonly understood to be a food product would qualify as a food, or if it's, a drink, then a beverage. Dietary supplements are included. And then for alcoholic beverages, those get a specific category. So essentially all foods, unless an exception applies, but the exceptions can be really tricky and a little bit, in some of the cases like naturally occurring exemption, they're actually a bit of a misnomer and not typically successful defenses that would be made.
So
maybe
Kent
has
Kent, do you have some comments on
that?
Sure.
Well, look, I think it's important that we even go beyond this. Prop 65 is not a food labeling statute. Prop 65 is a carcinogen or a toxin exposure statute. So it applies in California. When we walk in a building, it often has a Prop 65 warning. That's an environmental exposure that is being addressed. It applies in the occupational context where factory workers in manufacturing are exposed to some type of chemical in the air or in something that they're touching. So, we're focused in this discussion on food. Some of the new safe harbor warnings and some particular types of chemicals are guidance is provided with respect to food products from OHIHA, but food is just a small, relatively small subpart of the Prop 65 enforcement picture.
Terrific. So it's kind of an order of analysis question, really. The first issue is, do you have the substance that could lead to an exposure? and then you need to really analyze that. And then the question is there anything special that you have to do, or any special protections you may have if it's a food-related product and you look at it from that perspective, right?
In a way, so the focus on food and beverage here is that these particular warning safe harbors exist. But remember, these are just safe harbors, and at the end of the day, the goal is a clear and reasonable warning, because that's all that's required to comply. So you can provide a warning that wouldn't necessarily meet these specific warning regulations relating to food and beverage, say, but you, as long as it's clear and reasonable, and the burden's on the business to prove that, but as long as it's clear and reasonable, it can still comply with the Prop 65 warning requirements. So, I mean, if we're having a conversation about the potential like misclassification of something as, you know, a product, so then only the general consumer product warnings would apply for the safe harbor versus a food, so the food and beverage warnings would apply. The greater question is the warning that's being provided, assuming it's necessary, then would meet the clear and reasonable standard.
And interestingly, the next question of methods of transmission specific to restaurants, I think is fascinating in a way. From my perspective, having worked in the restaurant and food industry starting at age 15 and onward, this method of transmission requirement now strikes me as something that really requires anybody in that industry to get out a measuring tape and make sure that the sign is no less than 8.5 by 11 inches and understand how big a 28-point font is, right?
It is rather specific. It does say minimum, though, right? But also, again, this is a safe harbor, so if you want to ensure compliance, this would be the way to do it. If you want to do something different, you would have to make sure that the effect is the clear and reasonable warning. There's also something, you know, I should mention here, and Kent's going to talk about it a little bit more when he talks about ingredients. But, you know, it's not just this exposure that's happening at the restaurant level, right? I mean, there's a whole chain that goes on here from where the product or, you know, the ingredient originates all the way to the end consumer exposure, because there's exposures happening along the way. There's various parties that are involved in the chain of distribution who are going to have obligations with respect to warning, or at least telling people down chain that the warnings are required. In some circumstances, the warnings themselves, the actual signage, needs to be provided. So in the retailer context, oftentimes that is the case with a consumer product, where a manufacturer would actually need to provide the retailer with the signage. So there are a lot of moving parts to this. But when it comes to being a restaurant and providing this warning for purposes of notifying a consumer about a potential exposure, you know, the safe harbor is an obvious way to ensure that you are providing the warning that's required.
So I have a question, and it really applies to each of the slides on the food beverages side. It has to do with the language. You said here the warning has to be provided in English and in any other language used on other signage or menus. So it would strike me, if I'm a restaurant, then I know that I have a menu in English and also one in Spanish, or I have one in, you know, also in Vietnamese or Chinese or some other languages. How would others in the industry know what the signage is of the end user or reseller, or does it even matter from their perspective?
So they won't necessarily. Thinking of a hypothetical, let's just say you have a retailer who sells their food and has menus that are in both English and Vietnamese, and maybe they actually have a warning from a distributor that is required to be made, so they're notified of that warning. The retailer does need to make an assessment over what languages it is going to be providing the warning in, and that is an assessment that would be based on what other language their consumers are being exposed to while on the premises for purposes of ordering that product, or the food that would have maybe that product in it. So everyone at every point who's involved in this chain of distribution has their own assessments to be made, and with respect to the warning languages, the person who's actually providing the warning is the one who has to make that assessment at the end of the day.
Yeah. Now, the same issue applies, I guess, to alcoholic beverages, but can you describe the special rules for alcohol?
So alcohol has specific language that is a little bit different than the language that you've seen in the prior slides for just food and beverage, and actually that you would see for a consumer product. In those other cases, you would have one example usually, and in the case of the food at the restaurant, they did have a few other examples, not just one of each chemical and reproductive toxicant. But here is a specific warning about pregnancy and cancer risk and birth defects that goes a little bit more in depth than is required for the other warnings. Also, this alcoholic beverage warning would be in addition to any of the other warnings that might be required.
And does it have to be affixed to the alcohol or spirit in a certain way? Does it have to be, for example, on an attached label, or could you have it be signage nearby, or something that's hung on the product or a bag that it's delivered in?
So this is all going to depend upon the type of retailer or restaurant you're talking about. So in the case of a restaurant, that warning is going to have to be on a menu and likely a sign. But when you're talking about, say, a consumer going into a liquor store and purchasing the product, then your product is going to have the warning on it, most likely, that it should be there. And then they're also going to have a signage probably on the shelving. This is all stuff that's going to be worked out during the course of the distribution process and between contracts on who's responsible for providing what. But at the end of the day, the warning has to say what's required for the alcoholic beverages. Also, I do want to note that recently I did see under the new warning regulations some labeling on a beer can that actually was kind of like your generic warning for Prop 65, like short form with an exclamation point in the equilateral triangle. I think maybe the new warnings have sent some companies into a bit of a tailspin on what they're required to do. And I think it's still a little bit up in the air, so people are doing a lot of belt and suspenders.
Yeah, that's true.
Well, and you can see why. I moved to the next slide. Kent, you had alluded to this as well, that it's really an exposure statute rather than a consumption statute. And so the obligations are fairly broad. And Alex, can you describe briefly these three categories and how they work?
Yes, there are actually specific definitions, so I'm going to tell you each of them. For consumer product exposure, that's an exposure that results from a person's acquisition, purchase, storage, consumption, or other reasonably foreseeable use of a consumer good, or any exposure that results from receiving a consumer service. An occupational exposure is an exposure that happens in the workplace of the employer, causing the exposure to any employee. And an environmental exposure includes exposures resulting from contact with environmental media such as air, water, soil, vegetation, or natural or artificial substances. That last category, environmental, is kind of also a catch-all for anything that doesn't really meet the requirements for consumer or occupational exposure.
And it's interesting because in the food, beverage, and agribusiness industry, you kind of get a triple whammy, right? You have the environmental risk associated with the growing of the product, and then you have the value-added manufacturer who then acquires occupational risk, and then it's sent into the distribution chain for consumer risk. And Kent, you had referenced this before, what I called the ingredient catch-22. What's the issue that ingredient manufacturers have that's somewhat unique as compared to other people in the food distribution chain?
Well, it has to do with this concept that the real question is exposure, which in turn relates to how much of this offending ingredient that is or process that is causing the exposure the consumer is going to receive. So let's suppose that we have, just to use an example, let's suppose that we have chocolate chip cookies that we're trying to decide whether there's a Prop 65 warning requirement. And let's suppose that the chocolate chips in the cookies are the offending ingredient that has the chemical that requires the warning. The question is whether the average consumer exposure is going to require a Prop 65 warning. And so we are then having to ask a couple of questions. Number one, how many chocolate chips are in a particular cookie, and how many chocolate chip cookies is an individual going to eat during a particular designated period of time, which for me would be probably more than I care to admit. So all of those factors are going to create some very serious questions with respect to whether a Prop 65 warning is required. We received some clarification from OHIA on this particular issue, which essentially says that the manufacturer of a component part or an ingredient has to comply with the obligations, not only in the occupational context with respect to the chocolate chips here in our example, which are existing in bulk, but would also have to have some do some due diligence with respect to the end user, the consumer, and obtain some knowledge or engage in some diligence to try to figure out whether in the particular dosage scenario the end user is going to be exposed to a sufficient number of these or a quantity of this ingredient so as to require a warning. So you're not off the hook because you're the ingredient manufacturer and you're simply saying, well, I'm only contributing a small part of the overall product. You still have some exposure here with respect to the end user depending on the exposure levels.
So first you tackle one of the holy grails of chocolate chip cookies, and in a few slides I'm going to have to ask you about acrylamide in coffee. So I just don't know quite what to do as a happy consumer otherwise.
Right.
Pretty crazy.
Yeah, coffee and chocolate chip cookies are getting pretty close here to
exactly.
sacred ground.
And really what I'm hearing, from a practical perspective, is if you're an ingredient manufacturer or a manufacturer of something that could become an ingredient, right? So let's say that you're the chocolate chip cookie manufacturer, and obviously you're selling that whole, but you also may sell cookie crumbles to someone to put on ice cream, for example. Then you really need to look both upstream and downstream as to making sure that you understand what's going in and you understand how it's going to be used going out, and craft
absolutely.
your legal agreements consistent with that.
Absolutely, yes. And a
Now,
lot of our work in the Prop 65 space has to do with that chain of distribution and reviewing agreements on both the upstream and downstream and trying to do our best to, depending on who we're representing, to shift that responsibility to someone other than our client. There's a lot of work that can be done in the litigation avoidance context in that upstream, downstream context.
Got it. Now, I understand that there's a naturally occurring exemption, which means that there's no exposure if a certain kind of chemical is in food. Alex, what you've listed here arsenic in rice as an example. How does one find the list?
Okay, so first off, this naturally occurring exemption is it's a bit illusory. So unless OHIA has specifically, enacted a regulation that says your particular ingredient qualifies for this exemption, it's up to the business to be able to prove this. And Kent and I were talking before the presentation today about whether anyone actually has been successful in this, and he and I both haven't seen it. So the only one I know of why it's on here is arsenic and rice, and the reason for that is because OHIA actually in August of last year adopted regulations that specifically provided for certain, naturally occurring exemption levels for brown and white rice that would qualify for arsenic, inorganic arsenic, which is actually a little funny because we're talking about a naturally occurring exemption, and when you read the definition, which is on this slide, you see that it's supposed to be naturally present in the environment in which the food is raised, and it can't result from any non-human activities such as the addition of chemical fertilizers. But arsenic actually became this background ingredient, if you will, to rice as a result of human activity. So it's a little bit opposite of what the regulations actually say for OHIA to do what it did. But for anyone who manufactures or produces or distributes or sells rice, this is a good thing. So, don't get a horse in the mouth.
So Tony, who's listening in, asked an interesting question, and the second holy grail for me personally at least, which is access to caffeine. I call it nectar of the gods. And the question was, why, if there's a measurable amount of acrylamide in coffee, would that not constitute something that requires a warning?
Well, that's great timing because on the next slide we're going to be talking, or on, I guess it's already up, on the acrylamide, on this slide we're going to be talking about acrylamide. And we have seen an about face in California with respect to acrylamide, which is a chemical compound that comes from cooking products. It occurs in all types of products that are cooked at high temperatures, including and what obtained a lot of nationwide publicity, is dark roasted coffee. So as a result of dark roasting the coffee, a chemical that wasn't in the coffee before suddenly appears. The defense that was made by the defendants in a number of these cases, including Starbucks, was this is not something that we can avoid, because in order to have dark roast coffee, there's no way to accomplish the roasting without acrylamide being present. And they contended that it really had no significant health effects, and that the exposure level established by OHIA was arbitrary and way too low. After this case was litigated extensively, culminating in a loss for the manufacturers about a year ago, and then was up on appeal, there's been a little bit of an about face. A couple of things have happened. First of all, the FDA weighed in. Something we haven't talked about that comes up from time to time is preemption. And the FDA in August of last year wrote to OHIA and just sent them a gentle reminder that they are still in charge. Now, by that point in time, OHIA had already issued some new regulations saying that dark roast coffee doesn't, or Prop 65 label, But the FDA cited that and said, we want to remind you that with respect to acrylamide, we have our own standards, and we haven't issued regulations in the FDA from the FDA on acrylamide, other than some guidance, but we haven't issued hard and fast regulations. But we certainly can, and if we do, these will essentially preempt California's Prop 65 regulations. But since you've already sort of done the right thing, California, by sort of delisting, at least for dark roasted coffee, acrylamide, we won't take that step. So there's a little bit of tug of war that's taking place between the FDA and OHIA on some of these issues, where the FDA views OHIA as not being responsive enough to legitimate concerns of onerous regulations that are impacting industry. So as a result, we have somewhat of a reprieve for the coffee roasters, but it's important to understand that this is not across the board with respect to acrylamide. Acrylamide is still viewed as a harmful chemical by both the FDA and the OHIA folks. It is therefore a question of, is there a alternative way of processing the food such that the acrylamide exposure will be eliminated or minimized. So with respect to dark roasting, there is no alternative, but with respect to frying foods, French fries and potato chips and so forth, there are apparently alternatives that can be implemented to eliminate or minimize the exposure of acrylamide, and that's why there's been some very, very big settlements in the fried food context, while the coffee industry, nonetheless, after a great deal of time and expense and litigation and suffering an initial loss here in California, is finally now somewhat off the hook on acrylamide.
Now, you've identified the big five, which I know to mean 5 chemicals. And how did they get on the big five?
Well, I guess the confession is, this is just our big five. There's not
Perfect.
we just came up with this list as probably the 5 chemicals or areas of regulations that are should be of most concern to those in the food and beverage industry.
Got it. So I know that there are 900 chemicals that are on the list in total, right? So these are the 5
right.
that we're hearing a lot about in the regulatory and litigation context. Is that how you describe it?
And in the food space, in the food and beverage space in particular.
Got it. So the next one obviously is massive, and that's glyphosate, which is the chemical often used in herbicides such as Roundup and others. And what's the activity here?
Well, the issue here is not ingredients per se in a product, but looking at chemicals that might appear in trace amounts in the product, not because it was intended to be an ingredient, but because of the way the food product comes from an agricultural product and the chemicals that were used in treating the agricultural product. So particularly with respect to grains that are used in breads and cereals and so forth, under existing regulations, which are being challenged right now, the constitutionality is being challenged in federal court in California. There's been an injunction relating to this, at least for the time being. Depending on how that turns out, food manufacturers are going to have to focus not just on the ingredients, but the sourcing of the agricultural products and whether chemicals were used in the field make their way all the way to the consumer and, among other regulatory headaches, create a Prop 65 potential liability.
And I'm just going to highlight one component here of 1,100 micrograms per day. Obviously, the manufacturer won't know necessarily how much a particular consumer is actually intaking in a particular day, but it does emphasize kind of the crossover between the impact of manufacturing and also the scientific testing that is, effectively a practical requirement if there's a risk.
Right, exactly.
Now,
so we'll see what happens, particularly on the National Association of Wheat Growers case that is now currently before the Ninth Circuit on the constitutionality of the statute. So it's an interesting thing to be watching. If that goes south for manufacturers, I expect we'll see a fair amount of litigation in this space.
Now, the next chemical involves the packaging itself. And Alex, I know you had referenced before that the packaging can also create legal issues. But Ken, why would this be listed as one of your top 5?
So it's because BPA is a big issue with respect to canned goods. The industry, I think, has responded appropriately and has done a great deal of work to eliminate BPA from linings of canned goods and other types of food packaging. But it's still an issue that I think we need to be aware of, because apart from actual food packaging, there's throughout the chain of distribution, the processing and the cooking and so forth, food exists in a lot of different types of vats and containers and large pots and so forth that could potentially create Prop 65 liability along the way. And so there's some very specific regulations and safe harbors that relate to BPA, so I think it certainly merits being in the top 5.
And then rounding it out here, the last one?
So really the same thing with DHP. This is a chemical that is found in plastic, and we've had a lot of litigation relating to phthalates and other types of chemicals that are found in food packaging over the last couple of years, as well as outside the food context. And again, the concern here is not just the ultimate food packaging, but exposures that might be created when the product throughout the chain of distribution is stored in containers that have DHP.
And then Alex, lead?
So lead might be maybe one of the top chemicals that comes to mind for people when they think of Prop 65, and probably most respect to paint. But that can be an issue in the same way that arsenic would be an issue. It's present in the environment, and so as a result of that, ends up in things that you wouldn't expect it to. Here we've noted that naturally occurring is not a defense. This goes back to that conversation Kent and I had about that this is as a result of human activity. Just because it's present in the soil, for example, doesn't mean that it's going to qualify for the naturally occurring exemption.
Got it. So many of the kind of future-looking things we've talked about to some degree, for example, the FDA's shot across the bow in regards to the coffee and potential preemption options. But I would like your input, Kent, on the last one as we wrap up here, that courts are more sympathetic to responsible defendants questioning junk science. What do you mean by that?
Well, I talked a little earlier about the battle of the experts that sometimes takes place during that 60-day notice period. And, I believe that courts are very attuned to frivolous lawsuits in the Prop 65 context. They're also very focused on collusive type settlements where someone's going to pay off the plaintiff and they're going to agree to some sort of warning that's not really required. And as part of all of that, courts, in my view, are increasingly open to push back that this is really not well-founded scientific theory, that there's a real exposure here. And I think the best example of that is the glyphosate litigation, in which the court said, I don't think that a Prop 65 warning is really required because there's a great deal of disagreement here as to whether this is an exposure. This is, something that stems from a lot of concern in Europe, in the EU, but looking at the science, courts sometimes, in my view, are pushing back. And
in the last 60 seconds here, you're kind of teeing up really the top three things that somebody could do. I put me, meaning, what can I do next to help make my company better protected? And it sounds like one of the things that I could do is drill down on product testing, right?
Absolutely, and it needs to be product needs to be tested on a regular basis. We have situations sometimes where a raw material manufacturer will change sourcing and not inform. That testing needs to be done regularly. Second and third opinions, various protocols applied. Thinking like a Prop 65 plaintiff when doing the product testing.
And then what would be the other two things that I could do to help improve my company's risk profile?
Well, I think you should really focus on what's going on in your particular industry or sector. The nice thing about OHIHA is they do have a very efficient and impressive website where all of these 60-day notices are posted. And it has a pretty good search engine where you can go in and you can search by chemical, you can search by product, and you can find out what types of 60-day notices are being sent out, because these things tend to go in droves. One party will be hit with the Prop 65 60-day notice letter, and then a bunch of other parties in the industry are hit as well. And so what's going on in your particular industry and the sort of the hot areas, I think is very important. And then I guess the third is the upstream-downstream relationship, trying to figure out how to avoid liability by pushing that responsibility to others, particularly the manufacturers that you're buying from.
To some degree, you're really talking about hiring counsel like yourself and Alex to look at the reps and warranties and also indemnity, both directions, so you understand where do you sit as far as the liability is concerned, right?
Yes, absolutely.
Terrific. So thank you so much for a great presentation. I learned a ton in the process, and I'm confident that the attendees did as well. For the attendees, if you'd like continuing legal education credit, you will need to complete the sign-in sheet that was included in yesterday's reminder email. And then our CLE provider manager, Michelle Hubble, will send a CLE certificate to you. And if you have any questions on this or other food and agribusiness related topics, and in particular in product liability and Prop 65, I highly encourage you to get in touch with Alex or Kent, and they'd be delighted to talk to you about unique situations that are faced by your company. So with that, Alex, Kent, thank you so much, and thanks to everybody who attended as well. This will end the program. Thank you.
Thank you.
Thank you.